argument on the statements, the court hears not the most expert opinions but those most favorable to the respective parties, and partisan experts frequently appear for one side. Section 45 of Evidence Act allows expert evidence only for foreign law, science, art and handwriting, or fingerprint authenticity. Before a court accepts an expert views, he or she must be qualified. Generally, experts assist judges with decision making. Only the courts select the supposedly objective and independent expert witnesses and not the parties. Regardless of their conclusiveness, experts' opinions are essential. However, judges are not compelled to follow the opinion of experts. Vernon Ong, Judge Court of Appeal in Batu Kemas Industri Sdn Bhd and KMTNB, explains that an expert must help the court achieve the right decision even if it compromises his client's case. This duty above any obligation to the client. Independent experts should testify. Expert views are only significant if they help the court decide the case. The expert must stay impartial during the investigation. One side shouldn't have hired him to give an opinion before the procedure. Getting close to one party should also be against the law. The expert witness must be fair and unbiased. The Supreme Court Justice today told experts that they must avoid the risk of taking side and advocating for their instructing parties. Hamblin said witnesses shouldn't become advocates and should give evidence so you cannot tell who instruct them. Independence and impartiality are fatal to an expert's credibility, he said. Any hint of partiality will taint all, so avoid it. The expert duties. In the case of Whitehouse and Jordan 1981, expert testimony provided to the court should represent the expert's independent opinion unaffected by litigation. An expert witness should provide the court with impartial, unbiased opinion on subject within his expertise and as stated in the Polyvat Limited and Commercial Union Assurance 1987. The expert must follow specific professional principles and rules to achieve these general principles as follows. First, the experts must avoid bias and prejudice in their work and assessment. When preparing and producing the expert opinion, he must be neutral and objective. An expert should declare at the start of judicial proceedings that he or she has no shared interest with one of the parties and should not receive conflict of interest instruction. A judge or appointing party can approve an expert's guidance. If expert's instruction cause conflict of interest, he or she must alert all the parties and may resign. In Pubalan Anak Lelaki Perumal and Public Prosecutor 2020, the court outlined the expert witness obligation, stating that being called by one party does not distract from overriding duty to the court. An expert witness must aid the court within his knowledge. The duty trumps any obligation to the person who instruct him or pay him.
On the issue of corruption, a possibility within expert evidence, according to Section 155B Evidence Act 1950, derives that the credit of a witness may become a question and nullified by the court if the opposed party can prove that the witness has been involving in receiving bribery or accepting any type of corruption in providing his or her evidence towards the case. Now, this reflects that an expert witness is being paid and instructed only by one party. Therefore, the provision is there to safeguard the justice from possibility of corruption. Now, the case of AG and Hitchcock, which was decided in 1847, provides the principle to the existence of Section 155B Evidence Act 1950. The case was about the witness who was asked during cross-examination whether he has said to be receiving bribery from an officer of the Crown to testify in the court. Judge in the case Pollock CB held that it could not be originally have been proved that the offer of the bribe had been made to the witness to make a particular statement, now the bribe not having been accepted by him. Further held by Addison B, the circumstances of the witness having offered or accepted a bribe shows that he is not equal and impartial, which derives that the statement made had a tendency not to be relied upon by the jury as it was back then. So it can be concluded that corruption is possible. However, Section 155B of Evidence Act 1950 is strictly monitoring any form of corruption or bribery among the witnesses. particularly expert witness, which by the discretion of the court, supported with evidence from the opposing party, the testified evidence or the witness itself shall be discredited by the court.
Indeed, the experts are paid and instructed by one party only, yet it doesn't mean that his opinion will be biased. This is because the expert may be asked to explain on his opinion. The court will evaluate the expert opinion and will use its discretion whether to accept or not the evidence given. Bear in mind that the initial responsibility of expert opinion is to give opinion that clear and precise that provides sufficient understanding to the court to enable a determination of the fact in issue. With reference to the case of Ong Chon Tao against R 1963, Winslow Judge stated that the expert called by the appellant would naturally tend to give evidence in favor of the appellant. In this situation, such witness can be said to be biased. However, bear in mind that the opinion given is only to help the court on technical and mechanical matters and not to draw inference or conclusion. It is the function of the court to decide based on the opinion and give conclusion. Thus, there should be no issue on biasness as their opinion just to assist the court. With reference to Section 51 of Evidence Act 1950, it stated that whenever the opinion of any living person is relevant, the ground on which his opinion is based are also relevant. Based on this provision, mere opinion of the expert witness must be accompanied with reasons or rationale. Thus, the court must given the benefit to understand why and how the opinion were made so as to enable the judge to make an informed decision. Even though the opinion may seem like bias, the explanation of the expert witness on the opinion may be the key point for the court to accept the opinion or not. Thus, there should no issue on bias on the part of the opinion of the expert as they did have responsibility to justify such opinion made. In case of public prosecutor against Chia Leong Fo, Augustine Paul Judge stated that the report related to matter pertaining to expert evidence must contain reason for such a conclusion. The bare expression of opinion has no evidentiary value.
When it comes to expert opinion, Section 45 of the Evidence Act 1950 cannot be forgotten. There will come a situation when the court is in need to form an opinion in matters of foreign law or of science and art or as to identity or genuineness of handwriting or finger impression. Then, an expert opinion can be taken into consideration and be regarded as relevant. But the question is what happens if there is conflict between opinions of expert or substantial disagreement among them. In the moment as mentioned above, for example such as in the issue of trading or the value of piece of land, the judge may request the expert to give their opinion on this matter. It can be seen in Tan Poh Lee and Oz and Tan Kin Chu and another 2017 where there are 7 medical experts that produce 7 different medical reports. However, the final decision will depend solely on the judge as stipulated under the case of Nilai Tri Porcelain in Sendirian Berhad and Berjaya Sompo Insurance Berhad 2013. According to the case Kamda, Sendirian Berhad and BP Chandra Balvantrai and others 2017, Nalini Pathmanathan JCA explained that the judge is not obliged to accept the expert's view and if the judge rejects the expert judgment, he or she must do so on reasonable grounds. Thus, expert opinion only advises the judge and the decision will be at the judge's discretion. When the experts have different opinions on the same subject matter, the court may use its own discretion to analyse and observe for appropriate decision. In the case of Maju Ikan Sendirian Berhad and Barclays Bank PLC 2014, where this court believed that if there are contradictory expert opinions, the judge is permitted to apply his own judicial evaluation and accept one viewpoint over the others. For example, in the case of the Kuala Selangor Rubber Company Limited and Pentadbir Tanah Kuala Selangor 2022, in the debate over the value of the property, the area of knowledge should be the assessor and there are 2 fields of expertise involved in valuing the land. Both have different expert opinions about the value but the judge eventually accepts their combined expert opinion on the 2 best comparables. Consequently, the precedent provides the court with the credibility and authority to consider the expert view. The judge may not have knowledge regarding the particular field of expertise, but the judge has a broad knowledge about the law that shall be applied to ensure that the fairness and justice are obtained when substantial disagreement arises. Based on the case of Wong Swee Chin and Public Prosecutor in 1980, Raja Azlan Shah ruled that in the course of elucidating disputed questions, aids in the form of expert opinion is in appropriate cases placed before juries or judges. But except on purely scientific issues, expert evidence is to be used by the court for the purpose of assisting rather than compelling the formulation of the ultimate judgment. In the ultimate analysis, it is the tribunal of fact, whether it be a judge or jury, which is required to weigh all the evidence and determine the probabilities. It cannot transfer this task to the expert witness. The court must come to its own opinion. When expert witnesses are called to give evidence in the court, the report should only be used to corroborate their evidence. In every case, the expert's opinion always assists instead of rules the judgment. The expert may know what should and ought to be done, but they are not aware of legal principles and equality in the sense of law. Therefore, it is irrational to argue about the credibility of the judge to resolve the dispute that has arisen.